Good evening, friends. As we had informed those who are connected with us that we would do the service law series and understanding service law from a lawyer, P.S. Rajagopal, a senior advocate, who not only teaches us service law, but he does a great service to the human and mankind, and especially to understand the perspectives of service law. And today is part 7. They say part 7. 7 has its own connotation. Maybe it is music, maybe it is several colors while we played the rain. And promoting the legal aspects, especially in the service law. The 7th part will always be close, and that's why they say it's part 7. And it is all promotion on the and educating on the service law. And from none other than P.S. Rajagopal, who we always like tell that Trivikram has been and his associates have been the connecting point to help us to connect with a person who is not only an epitome of knowledge, but like I earlier said, that he is creating a great human service towards legal empowerment. What all the judges nowadays speak of, that there should be free legal literacy. And he's a part who is giving his inputs larger than life. Over to you, Trikram, and then we will ask Mr. Rajagopal to share his knowledge on promotion part 2.
Because you have said it all. And since yesterday, since the time that I have updated my WhatsApp status, I've got so many messages. And to be honest, sir has mesmerized all his audience. They were all very keen in attending this webinar. And today, to be honest, even in the High Court, I had gone physical, and a few of them, they were just mentioning today evening, I'll be logging in, and they were just mentioning about the webinar. So that is the impact that sir has created on his audience. As usual, sir, we are so lucky to have you here. So a very warm welcome to you, sir. And my other colleagues who have logged in, a very warm welcome to all the audience. A special welcome to Ashwini Rajagopal ma'am and also Mr. Jayant. And many thanks to Mr. Vikas Chatrat for these webinar series. Thank you so much. Over to you, sir.
Thank you, Vikas. Thank you, Trivikram. I have always been benefited by talking. Talking in the court is necessary as an advocate. Talking outside the court is a thing that teaches me so much, which perhaps no university can teach. They say what they do not teach in Harvard School of Business. Whatever they are unable to teach in National Law School also, I think I learned in the corridors of the High Court, where some colleague comes up and pops a question at me that makes me thinking, because questions will be such that there can always be more than one answer. And choosing the correct of the two equally, apparently clear correct answers is what sharpens our intellect and our knowledge. On the last occasion, when I spoke of promotion in part 1, at the end of the session, several questions came up, particularly on aspects that I had not covered. That is more about disabilities a man faces, an employee faces in being eligible for promotion. That is what is commonly called as sealed cover procedure. Why this sealed cover procedure? When it can be applied? And most importantly, one question that was asked to me in the last session was, what is the remedy against delay in the proceedings that takes place because of which you are kept in sealed cover? Then, of course, certain questions were asked, which I said I would cover in the next part. That is about the reservation promotion, then vertical, horizontal, then whether it should be post-based or whether it should be vacancy-based. I would try to cover those aspects which were not covered in the first part. The first thing is Why this sealed cover procedure? Because law is that when a person's integrity or his work related conduct is under a cloud, it would be incongruous to say that we are proceeding against the employee in a disciplinary proceedings or in a criminal proceedings, and at the same time keep on promoting him. It looks very, very anomalous. At the same time, while saying that no, when he is under a cloud, he should not be promoted because it will give a wrong picture within the organization and also outside the enterprise. Allegation is after all an allegation. It remains an allegation until it is established. Suppose after 5 years or 6 years or 7 years, he is exonerated. Then he should not suffer because different personnel would have come into the departmental promotion committee, or the period of performance for which the appraisal is made should not differ from candidate to candidate. And therefore, there is a need to protect the interests of the employee so that he has a level playing field with other candidates competing for promotion with him in the same year. Therefore, the harmonize the institutional interests as also the interest of the employee who is under a cloud. This sealed cover procedure was evolved. Earlier years, say about 35-40 years ago, this was unknown. This concept of sealed cover came with the advent of 80s. Before that, there was no sealed cover. Yes, he has been charge sheeted. We will see if he is exonerated. That was the attitude. Then came this concept of sealed cover. First thing we have to understand is why this sealed cover procedure is put in place at all. As I was telling, it is to ensure the institutional interest, and it is to ensure that a workplace incongruity or anomaly does not become apparent where a person is kept under suspension, yet during the suspension period is promoted. A person sanction is granted to prosecute him, yet when the prosecution is going on, he is promoted. Or a departmental charge sheet is issued and then simultaneously promotion also takes place. To avoid this anomalous situation, this was put in place. Then the next question that arose before the courts was, when can you apply this sealed cover procedure? That is the point at which disability to promote a person commences. If something commences, then when it will end. And in between these two termini, that is beginning and the end, if there is a long duration, what is the remedy for the employee, at the same time protecting the interest of the institution? These are the things that we have to understand in the sealed cover. There was at some point of time a thinking that the moment an FIR is registered, you can apply sealed cover procedure. In the matter of disciplinary proceedings, there was a thinking that the moment you think that this man has committed some misconduct, therefore an investigation has to be ordered, then also sealed cover procedure can be applied. These were the primitive thinkings, I should say. Or these were the thinkings at the very nascent stage of the concept itself. All these got crystallized into a definite position by judgment of the Supreme Court in K.V. Janakiraman. In K.V. Janakiraman, confirming full bench decision of the Central Administrative Tribunal, except on one point. What is that point? I will tell a little later. Supreme Court said there are 3 occasions under which sealed cover procedure can be applied. One is simple, when a person is under suspension. Normally, suspension is ordered when the employer comes to conclude that this is a matter which may end up in regular departmental action for imposition of major penalty, or some vigilance investigation is going on and it may result in a criminal proceedings. These are the circumstances in which a employee is normally placed under suspension. Therefore, the first condition under which sealed cover procedure can be applied is when an employee is under suspension. Second situation is where disciplinary proceedings is initiated, or to put it differently, where disciplinary proceedings are pending. Third is where a criminal proceedings are pending. This word pending, both in regard to disciplinary proceedings as also regarding criminal case, they were interpreted in K.V. Janakiraman and said the disciplinary proceedings commences to be pending on issuance of charge sheet. Therefore, unless a charge sheet is issued to the employee, you cannot invoke sealed cover procedure. Insofar as the criminal proceedings or criminal case is concerned, the Supreme Court said that they start their pendency from the time when charge sheet is filed in the court. Therefore, 3 situations envisaged by K.V. Janakiraman are: employee should be under suspension, or these are all alternatives. Departmental charge sheet must have been issued, or criminal proceedings should be pending. These are the 3 circumstances under which the sealed procedure can be resorted to, and not a day earlier. Suppose Chief Secretary, a very inconvenient IAS officer is there. Chief Secretary may be thinking, I have to issue some charge sheet to him. Merely because there is a thought process going on, you cannot put him in sealed cover. To put him in sealed cover, there must be a proceedings pending. Of course, what is pendence of the disciplinary proceedings? This became the 2 benches of the Supreme Court took a little distorted view. Even though in Janakiraman it is clearly said that charge sheet should have been issued. In H.C. Purana's case, one bench headed by Lordship Justice K. Ramaswamy took a view that, after all, before issuance of the charge sheet, a decision has to be taken to issue a charge sheet, or to put it in the words of the Supreme Court. Decision to issue a charge sheet precedes issuance of charge sheet. Therefore, it is enough for the disciplinary proceeding to be considered to be pending for invoking sealed cover procedure. The bench in H.C. Purana said that it is enough if a decision has been taken to issue the charge. Actual charge sheet need not have been issued. This went a step further in the next bench, that is Keval Verma's case, where Supreme Court said, suppose an FIR has been filed in respect of a crime, and on the basis of the FIR, a decision has been taken to initiate disciplinary proceedings. That is enough to put him in sealed cover. Luckily for us, such a view was short-lived. Of course, such a view was expressed even in R.S. Sharma. These three judgments were very short-lived, and thereafter Supreme Court took a very clear view that generally, ordinarily, a disciplinary proceedings is set to commence only on the date charge sheet is issued, and therefore disciplinary proceedings cannot be initiated. The sealed cover procedures cannot be invoked unless a charge sheet has been issued. Of course, issued means what? Whether it is enough if the charge sheet is signed, or whether charge sheet should have been dispatched, or whether charge sheet should have been served. In the issuance of charge sheet, there are three stages. One is sign, second is send, third is receive. The predominance of judicial opinion now is it must have not only been signed, but it must have been put in dispatch to the employee concerned. That is, it must have left the office of the disciplinary authority. Then regarding pendants of the criminal case, even today, we have some state governments whose standing instructions prescribe that the moment a sanction is given by the competent authority to file charge sheet against an employee to the investigating police, that is enough to invoke the sealed cover proceedings. Of course, validity of such standing orders, wherever they are there, has not yet been tested before the Supreme Court. As on today, the settled position before the Supreme Court is that the charge sheet must have been filed after completion of investigation. Then the real question is, what is the remedy against delay? We have seen, as is happening in these days, when Enforcement Directorate is playing a major role than CBI itself. Person is kept under suspension because what is that EC or something is said in respect of Enforcement Directorate's proceedings. That is registered and proceedings go on. If he is lucky to be outside the prison or outside the custody, even at that time, the proceedings can take easily 7 to 10 years. And they rarely conclude within a reasonable time. Or let us say a prosecution in respect of disproportionate assets. Normally, it takes 3 to 5 years for the proceedings to come. In such an event, how the employee's interest will have to be protected, even while not compromising the public interest. Because it is not in public interest to promote a person facing trial. But at the same time, the employee's interest has to be seen, and his interest will have to be protected in case of ultimate acquittal. Therefore, the concept of reviewing the sealed cover application has been incorporated by most of the state governments. And I have to say that some state government has not yet incorporated it in their OFs. As for example, the state from which I am speaking, the state of Karnataka. Karnataka rules have not yet been amended to say that periodical review has to take place. But Supreme Court has more or less now clearly said whether there is provision for such a review or no such provision is there in the rules or official memoranda, as the case may be. Once in 6 months, the cases of sealed cover promotions will have to be reviewed. Reviewing on what grounds? First is how much more time the proceedings are likely to take. Second is, from the study of what has happened till then, what are the chances of acquittal or conviction or charge being proved or exonerated, all these things. Most important is whether the employee has been responsible for the delay or delay is for reasons not attributable to the employee. Here again, there may be genuine delays where the employee can be said to be responsible for. Suppose in a departmental proceedings, inquiry officer appointed is totally biased, or inquiry officer appointed is a person whom the employee is able to demonstrate is premeditated, or the entire contents of the charge sheet do not make out the offense or charge leveled against it. These are the cases where the employee himself goes to the court and gets the stay of the proceedings. Even then, in such cases, the employer cannot say that, look, you have gone to the court, obtained stay, therefore I will not review. Such a view is impermissible in law. The reasons for delay, even if apparently attributable to the employee, the reason for which he has gone to the court and stalled the proceedings will also have to be seen. Then there is another clause. In addition to these 6 months reviews, at the end of 2 years, if the competent authority on reviewing of the case comes to a conclusion that there is no reason not to promote, then the sealed cover will have to be opened and promotion has to be granted. Of course, it will be called as ad hoc promotion or officiating promotion, or which will always be subject to final outcome of the proceedings, whether it is a disciplinary or criminal. Therefore, the sealed cover procedure cannot be invoked before charge sheet is issued or charge sheet is filed. It has to be reviewed every 6 months, and at the same time, the end point is, say, within 2 years, if the proceedings do not see a conclusion, then you will have to promote the employee, give effect to the sealed cover tentatively, though not finally. That tentative giving effect to will always be subject to the final outcome of the proceedings. Then, when it can be opened, that is, what are the conditions for opening of the sealed cover on conclusion of the disciplinary proceedings or criminal proceedings? Full bench of the tribunal had taken a view that if the penalty, whatever be the penalty that is imposed, the employee should not suffer double jeopardy or second penalty by denying the promotion also. That was the view expressed by the full bench of the tribunal. In the matter went to Supreme Court in KV Janakiraman. In KV Janakiraman, Supreme Court accepted every finding of the full bench of the tribunal, but reverse this finding about what is the effect of penalty at the end of the proceedings. Supreme Court said that any penalty, even if it may be censured, it is a statutory penalty. If any penalty, however small, is imposed on the employee, at the end of the disciplinary proceedings or at the end of the any other proceedings, then sealed cover cannot be opened. It remains sealed. Therefore, unless there is full exoneration, the sealed cover cannot ultimately be given effect. If by way of midterm review, a person has been promoted ad hoc on the basis of such a review, then that promotion he loses, even if he is imposed the penalty of censure. In fact, in K.V. Janakaran, the argument was, as long as the punishment is not a reduction in rank, the promotion should be given. That was rejected, and I feel it has been rejected for valid reasons. But this question of delay is what really troubles the employees, because cases are not lagging where a disciplinary proceedings or FIR or criminal proceedings are started just to deny promotion to the employee, or at least delay the promotion to the employee. Then after 4 years or 5 years, he gets acquitted or exonerated. Then he will be promoted, means it will be like awarding a posthumous Paramveer Chakra to the employee. We should always remember while dealing with these issues that service span of an employee is limited. Earlier, it used to be around 35 to 40 years, perhaps when I joined service in 1972, before leaving the service for good. I was telling that I will have 40 years and 6 months service in this organization. Now, maximum age for recruitment have been enhanced to 35 years. Now the service span of an employee is got reduced to 25 years. In 25 years service span, if an employee is kept stagnant for 6 years or 7 years or 8 years by pending proceedings, 1/3 of the service would be gone. Ultimately be told, but you had not done anything wrong, you are exonerated. It is like telling that, yes, I have killed you for 8 years, but now I find you are worthy of living. Therefore, I am allowing you to live. This delay in proceedings is something that the courts are yet to grapple with to the full extent. Because invariably, the courts have not yet taken serious note of delay in proceedings and make it a rule of law that after a specified time, we will interfere if the sealed cover is not open, though the OM provides 2 years. For example, in case of Harsh Kumar Sharma, which is the latest on this sealed cover, the proceedings were kept pending for almost 11 years. And 11 years, the sealed cover was not open. And Supreme Court first it said, I don't remember the name of the party that arose from Punjab, where a jailer was charged for having a dinner at a party with the, not Jarnail Singh, it is something different. Jarnail Singh? No, there is one case where a jailer had a dinner or a gala party with a Chamanlal Goyal. Yes, in Chamanlal Goyal, a jailer had a party with inmates, and in the josh of the party, some inmates escaped. That was the charge. In the normal circumstances, it appears to be a very grave charge. But even in such case, Supreme Court said, though the charge is grave and inquiry has to be proceeded with, the sealed cover will have to be opened and tentative promotion will have to be given, which will remain subject to the ultimate outcome of the proceedings. I think this much about the sealed cover should suffice for our purpose, then straight away I go to the next issue, that is whether for a particular promotional cadre, one promotional cadre, there can be more than one feeder cadre, or whether quotas for different cadres is permissible within the promotion to the same cadre. This issue we come across normally in respect of two cadres. First is the engineering cadres, whom I always call as service law nurturers. It is the engineering cadres in service that have nurtured the growth of service law, service jurisprudence, particularly in the matter of quotas. It is always common to have before any court 3 or 4 active cases pending and being argued about the fight between diploma holder engineers and graduate engineers. The entire quota rule within the service jurisprudence, at least most of it has developed because of the fight between diploma holders and graduate engineers. Another group of cadres where we come across this issue is where second division clerks or first division clerks, typists and stenographers, they are all feeder cadres for a single promotional post of, say, office superintendent. In all these cases, Supreme Court has held very clearly, quota is permissible in the matter of promotions between two different cadres. There can be multiple feeder cadres for a single promotion. But that classification must be based on a relevant and rational criteria. What is the relevant and rational criteria? The development of law in this regard dates back to Trilokinath Kosa, which came from Jammu and Kashmir. Originally, under the 19th pre-independence rules, there was a quota for promotion to the cadre, what we are present day call it as assistant executive engineers. There was a quota for diploma holder junior engineers. There was a quota for graduate assistant engineers for promotion to the cadre of assistant executive engineers. It was for the reason that graduate engineers those days were very few. But subsequently, rule was amended, making promotion quota wholly for graduate engineers to the exclusion of diploma engineers. Then the question was examined with the Supreme Court, and the Supreme Court said, educational qualification as basis for classification inside the promotion quota is perfectly valid. Of course, long years thereafter, a discordant note, I don't say exactly discordant, a concern was expressed by the Supreme Court in one case which went from Tamil Nadu, that having quota is permissible, but it should not reduce the chances of promotion or promotional opportunities for diploma holder engineers to a nullity. That means a slight deviation was made and said that diploma holders also should have promotional opportunity to go to the higher cadre of assistant executive. But insofar as the further promotion to the cadre, higher cadre of executive engineers is concerned, in most of the states, today the position is the diploma holders who join as junior engineers, they can get 2 promotions, that is, first as assistant engineer, second as assistant executive engineer. And there the promotion stops. They cannot go to the level of executive engineers. And in some states, there are different institutions. In some institutions, diploma engineers cannot reach the level of assistant, cannot reach the level of executive engineers. But in some states, they can reach. In some cadres, they can reach. Therefore, first principle, insofar as providing quotas within the promotion to a common cadre is, there can be a quota based on educational qualifications. There can be differential eligibility service. For example, in most of the organizations, when you see the service rules, a graduate engineer can move to the assistant executive engineer's level on completion of 3 to 5 years of satisfactory service. Whereas for diploma engineers, it has been between 5 to 8 years. Therefore, a longer eligibility service is prescribed for the less qualified cadres, and a shorter eligibility service is prescribed for cadres consisting of or those engineers who are graduate. Both these have been approved by the Supreme Court. That is, there can be different quotas, there can be different qualifying services. But one essential factor we have to remember is that, suppose in a cadre, a common cadre, there are both executive engineers, graduate engineers, as also diploma holder engineers. They can be given differential promotional quota based on qualification. They can be given different eligibility services also based on qualification. But this classification should not deteriorate into discrimination based on birthmark. For example, let us say a diploma holder joins service, and during the while in service, he acquires graduation. He also reaches the level of assistant executive engineer. Once he acquires graduation, then if you say that, no, you were a diploma holder even when you were born in the institution, now you might have become a graduate engineer. Because of your birthmark, because of your birth as a junior engineer, you are not eligible for promotion. If such a stance is taken by the employer, that would amount to discrimination on the basis of birthmark alone. Alone is very important. Discrimination on the basis of birthmark alone, without any other rational classification, is held to be bad. Now, it is very common in service jurisprudence to find graduate engineers, or most of the time graduate engineers, coming and telling that, look, by providing a quota for junior engineers also to be promoted, our chances of promotion have been reduced. For that, Supreme Court has clearly said, while right to be considered for promotion in accordance with the rules in existence is a fundamental right under Article 16, chances of promotion is not a condition of service. Chances of promotion is not a right. Therefore, to sum up on this, quotas within promotion it is perfectly justified to have different quotas by providing different feeder cadres for the same promotional post. And such provision for quota will not be treated as either discriminatory or impossible, as long as it is based on rational criteria. Even qualifying service also could be different for different different level of education assignment. Higher qualification can be a real basis. Then the job content also could be a real basis, as long as the posting is not posting to a higher job content is within the within reasonable expectation of the employees, and more than one feeder cadre can be there in the matter of promotion. Now I come to the question of reservation in promotion policy. Reservation in promotions. First question that would arise is whether it should be vacancy based or whether it is post based. Until 1995, law in the country was that a roster, which is a cycle, it can be operated eternally. Suppose in a cadre there are 30 posts or 33 posts or 40 posts. Every time a vacancy arises, a next cycle, the roster can be operated as a continuous cycle. There were distortions in their implementation. Therefore, in R.K. Sabharwal, rendered on 13th February 1995, Supreme Court said 10th or 13th, 3 days, if there is a difference, kindly excuse me. In February 1995, it said that roster cannot be operated eternally. Once first cycle of vacancies or posts are filled up to the cadre strength, thereafter replacement theory will apply. Initial posts, they have to fill up according to the roster. After initial posts are filled up, what will be applicable is not the roster, but theory of replacement. That is, if a reserved candidate retires or gets promoted or for whatever reason leaves the cadre, that post should be filled up by a reserved category candidate. If a general merit candidate leaves the post for whatever reason, that should be filled up by general merit. This replacement theory came in R.K. Sabharwal, decided by 5 judges. But in R.K. Sabharwal, Supreme Court also said that the law we have declared today is prospective in nature. Prospective means promotions already made will not be reversed. They will continue. Then the next important development in the application of reservation in promotions was judgment in Indira Sani, where in Indira Sani Supreme Court said reservation in promotion is not available under the Constitution. What is available is reservation in initial appointments and not promotion. Then Supreme Court also, being conscious of the fact that in every state or in every enterprise, reservation in promotions have been given right from 1950 throughout the Constitution. Supreme Court said that in spite of this declaration in law, wherever there is reservation in promotion, it can continue for 5 years. Within that 5 years, the Parliament intervened and then first said that there shall be reservation in promotion. Then came Ajit Singh 2, where the Supreme Court said that reservation in promotion can give accelerated promotion, but it cannot give accelerated seniority. And it made a distinction. Seniority is governed by Article 16(1), whereas promotion is governed by Article 16(4). Therefore, there can be a senior, a reserved category candidate who is promoted earlier than the general candidate on the basis of roster will become junior to a later day general merit promotee, or what they called as catching up principle. Catching up principle was dealt with in detail in Ajit Singh 2. That was also legislatively overruled by the Parliament by amending the Constitution, that it is open to the state to provide not only reservation in promotion, but reservation in promotion with consequential seniority. Now, all these things were considered together in M. Nagaraj. And in M. Nagaraj, the ultimate conclusion reached was that promotion has to be post-based, as held in R.K. Sabru. Because that is the only way to ensure that promotion, the reservation does not cross 50%. Second is, the state will have, it is in the discretion of the state to give reservation in promotion with seniority and all. But before extending that benefit, quantifiable data will have to be collected and justified that because of backwardness, without compromising on the administrative efficiency, this reservation will have to be provided. Of course, one thing that was said was that creamy layer applies to scheduled caste, scheduled tribes also. It was said. Subsequently, in journalizing, it was clarified by another constitution bench, saying that creamy layer, insofar as scheduled castes and scheduled tribes are concerned, will not apply at the initial recruitment. But if the state so desires, it can apply creamy layer concept, which is generally applied to OBCs, even in respect of SC and ST, in the matter of promotions, because once they enter service, they would have overcome the disability of untouchability and extreme backwardness. Therefore, as the law stands today, creamy layer is not applicable in direct recruitment insofar as scheduled caste and scheduled tribes are concerned. But at the same time, it can be, and maybe it can be insisted upon also, perhaps, because whether somebody can insist upon it is a matter which is not yet, which has not yet come up for judicial review. The creamy layer concept can be applied even for scheduled caste and scheduled tribes while providing reservation in promotions. Therefore, the creamy layer concept in promotions can be applied. Then this reservation in promotions can be given, but it should be post-based and not vacancy-based. Then, after the initial posts in a cadre are filled up, replacement theory will apply and not the roster. These are the broad parameters of reservation in promotions. Only I'll conclude just saying one more aspect. That aspect being how many posts should be there for providing reservation in a cadre? UGC had issued an instruction that teaching cadres in a university, all teaching cadres, that is assistant professors, associate professors, professors, 3 cadres are there. Add up all assistant professors in every teaching department in the university and treat it as a single unit for working out reservation. Similarly, in cadre of associate professors, similarly in case of professors. First time Supreme Court said in that was not regarding teachers, but in respect to the post of joint directors in the Department of Indian Medicine in the state of Bihar. Chakradhar Parswan versus state of Bihar. There the Supreme Court said, no doubt there are 3 posts of joint directors, but they are not born in a single cadre, because one is joint director Unani, another is joint director Ayurveda, another is joint director of homeopathy. For each of these posts, a distinct qualification is prescribed, a distinct path to reach that place, that stage is prescribed, and they are not interchangeable. For example, a joint director Unani cannot be posted as joint director of homeopathy. Therefore, plurality of the posts is required, and each stream will have to be treated as a different unit for operating reservation. Then came the full bench judgment of Karnataka High Court in Rajagopal, Gulbarga University, where they said the teaching cadres in each department of study will have to be treated as a separate unit. A similar judgment came in Maharashtra also, that each teaching subject, qualifications being different, it will have to be treated as a different unit. Ultimately, Supreme Court approved Maharashtra judgment also, but then finally, as a settled principle, UGC's instructions were set aside by the full bench of Punjab and Haryana High Court. The UGC guidelines said taking all teaching departments as single unit. Now the law is that each teaching department will have to be treated as a separate unit. Therefore, the sum and substance of requirement of reservation is that there must be plurality of posts, and each cadre will have to be treated differently merely because the designation is common. You cannot treat all of them as one single. Of course, another concomitant issue is what is said in R.K. Subramanian, which flows, this concept flows from R.K. Subramanian. Suppose the reservation is 15%. Unless there are 7 posts, there cannot be reservation, because it is only at the 7th post the reservation number becomes 1.05, which becomes 1. Therefore, there must be plurality of the posts, and number of posts must be such that by providing one reserved post, the percentage of reservation does not exceed the percentage stipulated in that state. Therefore, these are the broad concepts of reservation promotion, and I have tried to cover what I could not cover conceptually insofar as promotion is concerned. Within these 2 sessions, I can only deal with the concepts. Rest, we will have to study and you study, I will also study, and all of us get encouraged. So that the concept, what is this for? Foundational concepts, we can develop into fuller ideas. Thank you very much. Now, because
Yes, sir. Thank you. You already built up the right foundation. I remember talking to you. You said one of the basic law in the service law is that if the foundation goes, the superstructure goes. So you have made the foundation strong, the superstructure will automatically stay. It's on the converse. I will ask Vikram, audio Vikram. Here? Yeah.
I think the chat box is free today. Sir has crystallized the topic so well that people no
Or I have been so boring that nobody thought of asking a question.
That could not be the reason, sir. I'm sure that could not be the reason.
So like we have been talking about R.K. Sabharwal, we have been talking about M. Nagraj, then we are talking about, we are also taking the session on the reservation judgment.
Yes,
like,
Maratha reservation. Yes.
Maratha reservation, yes. We did part 1 and part 2 also. Now, we would like to understand for in this regard only, like reservation, if one has to understand as a student, what basic judgment would you feel that one should first understand? Because these are all quite complex. Roster points, then how to go about it, interplay of the catch-up principles. Today we haven't touched catch-up principles. Sir.
Catch-up principle, I have said now that catch-up principle is virtually overruled legislatively by 85th Amendment to Constitution.
By giving
catch-up principle, Ajit Singh, it went on the basis that the Constitution provides for providing reservation in promotion and not reservation in seniority. The distinction that was made in Ajit Singh between seniority and promotion was seniority is a concept governed by Article 16(1). And reservation is promotion is a concept covered by Article 16(4). The two should not be confused. That is what the Supreme Court said in Ajit Singh 2. And it also said that, take the case like this. Assistant engineer is the basic grade. Next higher cadre, up to which the reservation is available, is assistant executive engineer's cadre. Roster would apply for promotion to the cadre of assistant executive engineer. A reserved category candidate, even though lower in seniority in the feeder cadre of assistant engineer, he gets earlier promoted to the cadre of assistant executive engineer by virtue of reservation in promotion. Then when the general candidate who was senior to him in the feeder cadre of assistant engineer, when he gets promoted according to his seniority, the cadre of assistant executive engineer, then he catches up. That is, though he is promoted later, he catches up with his seniority that was prevailing in the feeder cadre. He becomes, on that day, senior to the earlier promoted reserved candidate. This was in principle catching up. Catching up means late promotee catching up with the earlier promotee to have his seniority restored. For that, the basis was this. Seniority is governed by 16(1). Reservation in promotion is governed by 16(4). 16(4) does not provide for reservation in seniority. Or to put it in the words of Ramajois, who wrote almost 30 years ago in sitting as a single judge of the Karnataka High Court, there is reservation in promotion, but no reservation in seniority. This is ultimately the catching up. Catching up is a very, very attractive concept that was introduced in Ajit Singh. But To break it up into a simplest principle of law is, there is seniority in reservation in promotion. There is no reservation in seniority. That is the thing. Seniority will have to be still computed on the basis of Article 16(1). That is, when he would have reached that cadre without the aid of reservation. The date on which he would have reached the cadre without the aid of reservation will be the eligibility date for seniority. That is what was said in Ajit Singh. But that was annulled by 85th Amendment to the Constitution, which said state is enabled to provide reservation with consequential seniority. Then that was adjudged, validity of it was adjudged in M. Nagaraj. So to what extent reservation can go? The basic judgment we will have to take is Chakradhar Paswan versus State of Bihar. Then a judgment which is not very often cited. One Garg or something there is there which went from state of UP, where the Supreme Court said, rounding off, if you have to apply round off as to how many people can be promoted, it said that if the vacancy available is more than 0.5, you can turn it to 1. If it is less than 0.5, you have to ignore it. Then the third judgment, after if you understand that basic, then we come to R.K. Sabharwal. R.K. Sabharwal, paragraph 4 is difficult to understand. But if you keep 3 pens of different colors and underline to break it into simple sentences, you will be able to understand. Because in one paragraph, Supreme Court has said percentage of reservation. It has also said about the operation of roster should be done in such a way that ultimately the representation should not exceed the percentage of reservation envisaged. Then it has also said that a general merit, a reserved candidate entering the cadre on his own merit should not be treated as a reserved candidate. He has to be set off against the, he cannot be set off against the reserved quota. And fourth point also it has said, if large number of OBCs or scheduled castes get promoted on their own merit, then it is for the government to think whether reservation should be continued or not. But courts cannot treat them as reserved category properties. 4 different concepts have been said in one single paragraph. That is why you find it difficult to understand. But have 4 different color pencils. Pens are not good in that. Pencils. And do it, you will understand paragraph 4. Once you understand paragraph 4 and 5 of R.K. Sabharwal, then you go to last 3 paragraphs in Ajit Singh 2. There it is explained what is the meaning of prospectivity of R.K. Sabharwal. Don't read Ajit Singh for the rest of the paragraphs because now it has become useless after the Constitution amendment. But R.K. Sabharwal, Ajit Singh, all paragraphs except the last 3 or 4 paragraphs where they give a subtitle, prospective effect of R.K. Sabharwal. That is what we have to read. And R.K. Sabharwal is not a huge judgment, it is a short judgment. Thereafter, you come straight away to M. Nagaraj. You can ignore Indira Sani because crucial paragraphs of Indira Sahni insofar as reservation and promotion is concerned. It has been extracted in M. Nagaraj. Because most confusing judgment, according to me, the entire series is Indira Sahni. So many judges writing so many views. At the end of it, we have to read para 841 onwards to know what is the ultimate view of the Supreme Court. It is like, in respect of fundamental rights case, what is the view of the court? Just as last day, Chief Justice Chief Justice inserted that and all that, there was some adverse comment. Like that, we'll have to see the last, our conclusions. See, we should be able to understand our conclusions by reading the individual paragraphs. Where was the need to have that our conclusions separately means? If we read conclusions, we will not be able to know what is the final conclusion. Therefore, final conclusions they have to summarize. Therefore, please don't read Indira Sahni. Read M. Nagaraj. Thereafter, you read journals, where Lordship Justice R.F. Nariman, speaking for the Constitutional Bench, he said that M. Nagaraj is wrong to the extent of it saying creamy layer concept should apply to SC/ST. But it is not wholly wrong in the sense that when it comes to promotion, you can still apply creamy layer concept. Therefore, these four judgments, one is starting from Chakradhar Paswan, then R.K. Sabharwal, then M. Nagaraj, then journals. These four, they should tell us what is reservation, to what extent reservation can go, how the reservation will have to be applied. And Mr. Trivikram need not worry, because even though it is now close to 30 years of R.K. Sabharwal, State of Karnataka has not yet implemented the post-based roster. We still have that roster operated as Akshay Patra. Go on rotating. Have I been clear, or have been as complex as it was?
No. We will only ask that we are not using 3 pens, but we are using 3 different shades. Vikram is in yellow, you are in blue, and I am in red. So kindly elaborate these 3 concepts in a different way. What does R.K. Sabharwal say? We won't use the pen, but 3 concepts in your own subtle, clear, and lucid manner.
Thank you.
Mr. Venkatesh has a question. Firstly, he has appreciation for sir. Excellent session, sir. Thank you very much. The question reads as follows. An officer of a batch will have a higher basic pay after getting 10, 15, 20 years increments when compared to an officer who got promotion. What is the remedy for a promoted officer when step up is rejected by the department? Please advise.
That is, I think there is a fundamental rule 23 or something, if I remember, in government, where the stepping up of pay conceptually is provided. Stepping up of pay there is because of the basic pay stage at which the officer is situated in the feeder care at the time of his promotion. It is possible that there would be anomalies. But now, in government such as that is not, that does not arise, because there is a running pay band and then academic grade pay. In institutions where there is no academic grade pay, wherever there are overlapping scales, this bunching, and because of the bunching in pay fixation and promotion, junior drawing higher basic pay would arise. Somebody will have to very seriously challenge it, saying that follow the concept that is in the fundamental rule applicable to the government service, where they said if a earlier promotee gets a lower basic pay for than the later promotee. On these circumstances, then pay of the earlier promotee or the senior will have to be stepped up. There is another way of adjusting this overlapping. In some pay revisions, 4 or 5 stages are bunched into one in the revised pay scales. That is, persons who are in the pre-revised basic pay at 3 or 4 or 5 different stages, they get all clubbed into one single stage in the revised basic pay. This happened in some of the banks when officer service regulations were implemented in 1979, then in 1983 in some banks. There the solution evolved was, at that time I was not an advocate, I was a member of the negotiating team on behalf of the bank officers. The solution that was then arrived at, I don't say that it would be a complete solution. Stagger the increment dates. That is, person who had highest basic pay stage in the pre-revised scale, he will get his increment earliest in the revised scale. Then next 2 months later, third, another 2 months later. Like this, you stagger the dates of increment so that the salary differential is maintained between the junior and the senior. That was way back in 1985. 4 decades have passed by. I don't know what is the present position. But still, I think I am sure that the banks would have worked their way forward. If they have not worked their way forward, provision in the fundamental rules provides a clue. It is for them to ensure that they strive to get those concepts incorporated.
Venkatesh judgment question can also be solved in 2 manners. Let's assume there is a difference that there is a direct recruit and a promotee. And the direct recruitment gets the ACP and they say that you have already got promoted, you don't get the ACP. Then the Honorable Supreme Court and Commissioner and Secretary to the Government of Haryana versus Ramswarup Ganda said that you have to step up the pay at par. You cannot have the different pay on account of the different birthmarks.
That is the thing. That is the past seniority will have to be reflected in the basic pay, because it is the pay attached to the post, basic pay attached to the post, that determines your rank and not the total salary. Therefore, pay has always been treated with respect or with higher respect than total emoluments in service law. The fundamental rule, if you read, I don't remember the rule, it is 22 or 23.
22.
22 or 23.
Fundamental
22.
rule of pay stepping up.
Yes, 23 is lean, I think. Is something called lean.
22 says that pay protection. And then the Honorable Supreme Court and others have also developed that Ajit Singh too, that principle of catching up, and then you give the pay protection.
Catching, don't bring that catching up again. We will go back to somewhere else. Catching up is always
let's assume that the general category
catch up with the basic pay of the junior. That is the thing. That is called as stepping up.
For pay also they say that since you have caught up, therefore your pay is stepped up at par with them.
Pay is stepped up at par. That conceptually it is not, if it is not implemented in some organization, it is for those in that organization to seek remedies. There can be more than one remedy, but easiest remedy is organization and not court.
No, one of the remedies is to contact Mr. Rajagopal.
Definitely. Hey, don't campaign for me and then make me guilty of canvassing for business.
No, then all youngsters can always learn after the sessions of understanding of the service law they understand the canvas and the empowerment, they will always have a better sessions. They can understand the things. And thank you, sir, for the session. And thank you, Trikram, once again. Everyone stay safe, stay blessed. Namaskar. And we will keep on catching up with, maybe the catching up principles is just as in terms of Mr. P.S. Rajagopal, slight fading out. But Mr. Rajagopal, we will keep on catching up with you and we will always keep on having sessions with you. Over to you. Thank you.
Thank you. Thank you. Thank you.